My lords, before I turn to the lease that we've examined already, I just want to briefly make some comments about the estate as we have heard of it. Because the estate, obviously it's a particular estate and the charges which concern us, although as you've already heard, the scheme which is being imposed, or sought to be imposed, and which the Upper Tribunal rejected, was one which treats all units by class across the whole country rather than addressing the individual estate concerned. So we have 137 original units plus the caretaker's unit, 138 units. They're 1 and 2 bedroom flats and 3 bedroom houses. As the first tier tribunal said, it was conceived for communal living in that all areas outside the buildings were left open for general use by all residents. There are no internal common areas. The flats and maisonettes have doors out onto the common areas. And the reason why the £300 is contested is because a 2 bedroom flat of Howe's, my North East Limited, my client, is immediately adjoining another 2 bedroom flat, and one is paying 15% by way of service charge, or somewhere short of £50 per year, whilst she is charged £300. And to put that into context, as in her witness statement, which appears in the bundle but which appears to be undisputed, that £300 exceeds the amount of the actual cost of services.
So this is comparing 2 flats, one of which is a long leasehold and the other is a short.
Yes, that's right. Yes, because the 15% is what's charged to an assured tenant. Now the system of the £300 system, or £300 charge under the tiered system. So the tiers appear at page 156 of the supplemental bundle. My learned friend has taken you through those, but he's taken you through those by way of description of what is comprised in each tier, and they're fairly heterogeneous classifications. Some are, freehold are classified with leasehold in various places. We've got shared ownership with freehold and leasehold. Tier 3 introduces domus accommodation as well as the bungalows for the elderly. Tier 4, domus bungalows and so on and so forth. And Tier 5, the nearest to sheltered or protected accommodation. But in fact, the page 157 actually contains a list of the work which is done in relation to these properties. What services do I receive? In the middle of that page. These are and the list which follows that is almost entirely common to all of those properties. So there's very little which is identified as distinct to any particular band. We manage scheme bank accounts, we collect service charges, we set service charge budgets, we produce annual accounts, we recover service charge arrears, costs of providing service charge information to residents. Interestingly enough, so almost the whole of the first 6 items listed are all about costs which are incurred simply by virtue of levying service charges in the first place. But then they get on to other material, costs of providing service charge information, costs of working with residents associations, costs of holding professional indemnity insurance, costs of carrying out periodic health and safety checks, but not specialist checks, costs of holding meetings with residents, management and supervision of house managers, storage and safekeeping of residents and tenancy details, providing information to advice agency, ombudsman services, the administration of buildings insurance, providing and managing maintenance contracts, carrying out consultation on management matters, major works and long-term agreements. That is the only one of the list, I'll come back to in a moment, which is distinctive for long leaseholders. And that's because of statutory consultation for substantial expenditure. Then drawing up risk assessment plans, providing copies of insurance policies, recovery of unpaid service charge and ground rents. All of the others would be applicable to any other of the styles of accommodation, as well as long leasehold accommodation. The reason why I just point that out is that obviously the general tenor of the submissions on behalf of my client is that it's a highly iniquitous situation. There's a massive disproportionate indeed, it's verging on the arbitrary division of service charges, and that there's a flat charge of £300 imposed for something which is very little distinction based on the works which have been or which are to be undertaken.
So is this right? Your point is that if you look at the definition of annual service charge in the lease.
Yes.
Sorry to take us back to the contract.
I was about to come to the lease, yes.
Yeah, if we go to the annual service charge in the lease, and I think we were looking at the one that's at page 29. Right. So it's at page 41. There we go, 42.
Yes.
You say that the frame of reference for a determination of what is proportionate or equitable or justified or whatever expression you want to use, I can't remember which one you used a few moments ago, is that it should be referable to the provision of management and maintenance of the buildings.
Yes.
By as that indicates, and you say that none of those services are, with one small respect,
yes,
any different across all the properties.
No, that's correct.
All the buildings, capital
yes.
B.
That's right. And you've been taken through the various clauses of the lease already to some extent. So, clause 4 is the covenant of what the landlord's obligations, and the bulk of that clause, so that begins on page 37. The first one is irrelevant because that's about enforcing regulation. That doesn't get mentioned later on, but the others generally do, and as you would expect, they refer to and relate to the good estate management and benefits to the occupiers of the buildings, in other words, of the estate. That's most clearly spelt out in clause 4, 4 and 6. So clause 4, page 39, talks about clean and reasonably lighted, tidy condition, passages, staircases, and so on and so forth. Then there's provided always that the lessor shall not be liable to the lessee for any failure in or interruption of services due to circumstances beyond the reasonable control of the lessor. And then the second proviso, and provided further that the lessor may alter or modify the services referred to in subclause 6 of this clause, if by reason of any change of the circumstances during the term hereby granted, such alteration or modification is reasonably necessary or desirable in the interest of good estate management and the benefit of the occupiers of the building. And then number 6 encompasses where it says that the lessor will engage and employ and discharge the wages and salaries of such staff as shall from time to time during the said term be reasonably required for carrying out works of maintenance, cleansing, etc.
So is this right? You say the structure of the lease, and this lease is no different from most, I imagine, is that the landlord covenants to provide certain covenants in certain respects to the tenant,
yes,
including the provision of what might be regarded as, quotes, services, unquotes.
Yes.
So, for example, repairing, maintaining, and where appropriate, decorating buildings, making good any defect in the structure or exterior of the flat or buildings, or keeping clean and reasonably lighted and in a tidy condition, etc., etc.
Yes.
And you say that prima facie, that's what the reference to an annual service charge encompasses.
Yes, essentially it does.
I mean, is there any sort of statutory definition of a service charge, or definition in any authority as to what a service charge conventionally covers?
No, I don't think so. I think what we're looking at here is a fairly conventional style of lease, as you'd expect. The right to buy leases. This might have a bearing on some of the issues, the broader issues that we're looking at today. Right to buy issue. Leases do tend to follow fairly standard forms in what they provide. but whether in those sorts of leases or in private leases, it's quite common for the service charge to specify that it will cover what the landlord has to outlay in terms of providing the services, maintenance, cleanliness and matters of that sort in relation to common parts in the building.
Does what it says on the tin. It's for services, and the person to provide the services is the landlord.
That's right.
And this, at the landlord's covenants.
Yes, and this one in subsection 4, that proviso allows for certain modifications to the services provided under section 6, which is deals with staff, maintenance, cleansing, and so on and so forth. And at the end of that subparagraph 6, we find that it also relates to what is reasonably required for the proper maintenance, running, and management of the flats and parking spaces and the grounds of the buildings. So there is a clear connection also between the management in general and the maintenance of these of the estate. They're closely related, and then that is also that close relationship is replicated in clause 5.2, which we've already been looking at closely, the first 5 lines, but relates in connection with the management and maintenance of the buildings, and in particular, but without limiting the generality of the foregoing, shall include the following. And then the first one is, unsurprisingly, the first one actually covers a lot of the expenditure which would have been identified as being a burden upon the lessor under its covenants in relation to this lease. So there's a close correlation between the two. Now, I just want to look at 5.2 in a little more detail, because it starts off with the annual service charge shall be the total of all sums actually expended or provided either directly, or in the case of services, service by the lessor's own staff, indirectly by the lessor during the period to which the relevant service account relates in connection with the management and maintenance of the buildings. So what we've got there, and that is the definition of the annual service charge. It links, as does the other provisions, management and maintenance, together. And then when it comes down to A to E, and in particular, but without limiting the generality of the foregoing, shall include the following. My learned friend characterised those as examples. I don't consider that that's necessarily quite the proper characterisation of it. It's not examples, it is providing an explanation, if you like, to some extent an enlargement upon the generality of the foregoing provision, and so it puts beyond doubt a lot of what has would have been included, one would have expected, in management and maintenance. So the first one, as I say, is subclauses 2 to 7 of clause 4, which we've just looked at. Then B, expenditure involved in the connection and maintenance of any communal television and radio aerial systems. That's actually specified in clause 4.3e, but nevertheless felt to warrant special mention. C deals with notices, regulations or orders for any competent local or other authority, which seems to be linked with clause 4.5, which relates to rates, taxes, duties, assessments, charges and outgoings whatsoever, whether Parliament, parochial, local or any other description, but would necessarily include dealing with all sorts of notices which are received. And then D, all fees, charges, expenses and commissions payable to an agent or agents whom the lessor may from time to time employ for managing, which is a paid by the word version of referring to managing agents. They're people who often do operate sites on behalf of lessors, so that they bring their expertise in relation to that sort of operation, and that they charge, and that charge is recoverable. That is the management charge. But it then goes on to make a useful and appropriate clarification, and that is to say that basically if it's dealt with in-house, then you can recover your costs in-house of doing that with a profit element. In other words, providing something which would replicate the external managing agent, but if it was provided internally. And again, that's consistent with those passages already read in clause 4.6, and is a useful summary. Now, E also deals with the employment of professionals. All fees, charges and expenses payable to any solicitor, accountant, surveyor, valuer or architect or other professional or competent advisor whom the lessor may from time to time reasonably employ in connection with the management or maintenance of the buildings, and then after the brackets, and in connection with enforcing the performance, observation and compliance by the lessee and all other lessees of the flats and buildings of their obligations and liabilities under this clause 5, including the preparation of service accounts and collection of service charges. So again, a useful clarification of the general principle. I'm not sure that I describe it as I say, as examples, but in certain of his written submission, Howe talks about there being 6 streams, these kind of 5, and then management. But it's not. That is simply not the case. Management and maintenance are considered together in relation to this, and then these streams or identification of them it forms clarification and of what is meant by those. It sets out, in other words, the specifics of management and maintenance.
There's actually 5 streams, aren't there? If there were streams at all, there'd be 5 of them.
Yes, that's right.
Yeah.
Can I just ask on a point on D, when they talk about provision by your own people, if you go back to 5.2, talks about services being provided either directly or, as in the case of service by the lessor's own staff, indirectly. Why is service provided by the lessor's own staff indirect?
I would very much like to be able to assist you with that. I can't see it because it seems to me that in fact those arguably were the wrong way round. that the lessor is providing services indirectly when they provide an agent to do the work for them. But
I just wondered if there was anything we could get from it. But okay, thank you.
I don't think so. But this focus is also to the particular estate, I say, and locally, because the references to buildings and the way that the whole lease is.
Can I venture a suggestion and answer to my Lord's question? Yes. It's the annual service charge should be the total of all sums actually expended or provided. It's expended or provided, i.e. it's actually paid or for which provision is made for payment. It's not provided. It's not provided in the sense of supplied. It's provided as in the sense of expended or provided. Either directly, i.e. you've paid,
yes,
or, as in the case of service by the lessor's own staff, indirectly by the lessor. In other words, you haven't had actually to pay out or provide the payment out. It's in-house. So I think it's expended or provided, but it's a provision for an expenditure. I don't think it actually means provided in the sense of supplied.
No, I'm very grateful.
So that would be my explanation. It may or may not be right, but I'll doubtless be told later.
But the point that I'm getting to, and it's a fairly obvious one, is that the annual service charge is a defined sum. It is for the purposes of exposition and numerator. It's what has to be divided up between the paying parties or those who are notionally paying, bearing in mind that only 22% of this estate is actually on long leaseholds. There's only 22% which are framed in quite this way. But there's nothing in there, in my submission, which allows you to impose some sort of proportionality or division in relation to those. It is simply, that is what the annual service charge is. The only time that, for instance, reasonableness is mentioned is in E, and that's when it's whether or not it was reasonable to employ or retain a professional or competent advisor to deal with certain issues. Everything else is simply a list, the lines, if you like, on the account.
Well, it follows, if you're right, in fact, it may not even matter whether you're right or wrong, whether these are clarifications or examples. You say that's missing the point. The point is there is a pot as defined by the first 5 lines.
Yes, absolutely.
And that is what is divided up. it's not any individual items in going to make up the pot.
That's right. The annual service charge shall be the total of all sums actually expended or provided for. That's what the annual service charge is. That is the numerator. You know, it especially is what it shall be, and it shall be the total of all sums, not the total of some sums and something else, not even the total of reasonable sums, but it's just the total of all sums.
Right, but the way, without getting hung up on the question of streams or anything like it, if certain items in this overall sum, the overall total, are specifically related to some but not others of the properties, why would it not, or could it not be, fair and proportionate, or fairly proportionate, or whatever the common expression?
Because fair and proportionate.
To allocate the total in a way that reflects that.
But fundamentally, because that's not what the lease says. Now,
why doesn't it say that, though?
Why wouldn't it say
why doesn't it say that you can't allocate the total in a way that reflects how some of the individual items that went to make it up were benefited certain properties but not others?
Because the way that this is expressed is that gives you the numerator. It gives you the total which has to be divided up.
Yes, but
it doesn't. Now, I apologise.
Sorry, but I understand your point that this gives you the total.
Yes.
Which you have to divide up.
Yes.
My question is at the next stage, when you are doing the division, the allocation, why would it be either unfairly proportionate or disproportionate to say, well, a big chunk of that pot, the overall amount, the numerator, in fact, the numerator, only benefited a certain number of the properties on the estate. Therefore, when deciding how fairly to apportion, we can take that into account.
My lord, what you're running into there is what I say is essentially impermissible. What would a reasonably objective reader interpret that to be? And the way that I would approach that, I know this mathematical approach might not be attractive in some ways, but there is a logic to this. If we wanted to stand back and say, well, why would you approach an estate of this sort in this particular manner? And the logic to that actually is probably rooted in the right to buy. Right to buy, so we're dealing with a government policy of, I suppose lawyers might call it enfranchisement, allowing people to buy out interests in properties which they're occupying. That was, because it was a government policy, that was a contentious policy, although it was also a very popular policy. And there could be very good reason why a government who was promoting that policy might have in its arsenal an idea that there should be strict equity between those who are taking advantage of that policy, buying out their interests with a subsidy, one of those 137.
When you said strict equity, did you misspeak?
Probably. So it's strict equality between.
Equality often is equity is often equality, but if you say strict equality, I think that I understand. That means it's an arithmetical division.
Yes.
If you say divide it equitably or fairly,
yes,
you potentially bring in something other than equality, don't you?
What I would suggest is that underlying an understanding of this sort, where you have a mixed estate which has been constructed as social housing, but some of those people are no longer going to be social tenants, and that complies or conforms with the government policy at the time, then you might well want to design leases which prevent the social landlord from loading any additional burdens or shifting burdens disproportionately between the tenants who have bought their long leases, 22% in this case, and the costs of the administration of the estate in relation to those who, if you like, were treated as notionally having purchased them. So there's the reason why there's a divisor of 137 is because if every property had become a long lease, that's how many properties you would have had.
Well, I certainly understand why you say it might be unfair or disproportionate to allow a landlord to load the service charge on certain tenants on an estate rather than others, if the reason for that had nothing to do with the benefit obtained on the ground from the services which are supposed to be provided in accordance to the lease. You know, in other words, if frankly you're making private tenants pay or subsidise those who, you know, are occupying by reason social housing,
Yes.
then you'd say that has nothing to do with how those different tenants on the estate share the benefits of the services under the lease. So contractually that's not appropriate. But why do you say that, for example, if there is a benefit obtained for some of the services as defined, which we looked at, by some but not all of the properties, irrespective of the nature of the tenure, that it would be outside the terms of the lease to allocate those costs other than equally? That's the question.
The approach which this lease must be taking in circumstances where we know from its own face that it's right to buy is that there are going to be some properties which are bought out and which some aren't. And the structure of the lease, as most clearly shown with the lease which isn't subject to the bill, that the one on 137 is to treat all the service charge costs which arise ordinarily within the operation of this estate, and then to divide them up notionally in relation to those who have not bought out, but specifically in relation to those who have. And in my submission, that's the logical construction. But when we come down to it, the reason why I depart from, or at least the way in which I would challenge the way that you're approaching this, is that the lease is very clear about what the annual service charge is. Yeah. That's very clearly defined.
Yeah.
And then, as my learned friend, I don't necessarily disagree with this, says, well, first of all, you've got to work out what it is, and then you've got to divide it up. So we are in a numerator and a denominator situation, I say. Now, that's most clear in the one that's not appealed. 137th is the denominator. But in the ones we are looking at, what do they say? So this one, number 84, what does it say at 2.1? The lessee shall pay to the lessor annually a proportionate part of the annual service charge as hereinafter defined.
Yeah.
As hereinafter defined. That's what, so it's a proportionate part of the whole. We know what the whole is because the whole is defined. The annual service charge shall be,
okay,
and then it explains what it is.
Yeah.
So that proportionality, proportionate part, is being applied to the aggregate sum. That's what the annual service charge means at 6.2. That is what is 5.2, and that is what is then where proportionality comes in, and that is the fundamental point in relation to this. As I said, it's perfectly rational in terms of why that might have been the intention of government for promoting this particular policy. There's nothing rendered irrational about it within the scheme, because it says, well, we're going to treat everybody who hasn't bought out as if they had bought out, and then we'll divide it between, you know, and so treat you as if this were an entirely private estate. Makes entire.
I'm sorry, hang on a second, wait a minute. I'm not following these submissions.
Well, okay.
The buildings as defined doesn't differentiate between the tenure, the way in which the properties are held. It's the buildings as a whole.
Yes.
So you say, right, we look at what's been spent or provided for by the landlord during the year on that.
Yes.
So the landlord says, actually, we had our Christmas party back at the ranch, and so we put that into the service charge. You say, not on your life. That just doesn't fit within the terms of the clause at all. Even on the most extravagant basis of keeping management going, that's not in. Understand that sort of argument. So you trim down your pot, you trim down your total of the sums properly expended as defined in 5.2.
Yes.
You've got your number.
Yes.
And that's for the buildings as a whole, the whole estate. No differentiation between how those 138 properties are held.
Yes.
You then have to decide what is a proportionate part or a fair proportion, I think I was corrected, of that total to allocate to each of the 138 properties, or at least those which aren't covered by the lease, which says it has to be arithmetic.
Yes.
You say, I think in answer to my Lord's question at the start of your submissions, in essence, that has to be equally.
Yes.
It has to be an equal division.
Yes, and at the very least, that's the starting point. Yes.
Okay, I wouldn't disagree with you on that. But why do you say you stop there? Why do you say you start and stop with an equality of division?
Because
given that it is said to be either a proportionate part or a fair proportion.
Because proportion, I say, in relation to this, a proportionate part or a fair proportion is an indicator that it's intended to be a fraction, or a fraction of the whole.
Well, it will necessarily be a fraction.
Well, my lord, I wish that were the case. But
no,
of course, my learning.
You mean an equal fraction?
No, I know. Let's just start with that comment about a fraction, because at the moment, what is being contended for by the appellant is not to treat it as a fraction, but to take a frankly, what I would submit is an arbitrary sum, the £300,
yep.
And so we're going to treat that as the management element for you, irrespective of what the annual service charge numerator is. Irrespective of that, that's going to be £300.
This is a new submission, at least to my ears. The words "a proportionate part," you say, should be read as if it was a fraction.
Yes.
Right, that's just a new argument. Isn't it?
Well, it is always going to be a fraction.
Well, of course, every number is a fraction of another number. But I mean,
no. Well,
but it's always going to be
to avoid the complication. I think what you've actually just been saying is you can't make the division on the basis of a factor or a justification which has nothing to do with the provision of service charges. You say it was arbitrary because they just picked a number, 300, which seemed to have nothing to do with, it was all to do with tenure, and tenure seems to have nothing to do with the actual provision of service.
Yes.
But my question is to try and get you back to your argument. Why do you begin and end with an equal division of the whole? Say, for example, let's say that in 1 year, part of the annual service charge for management and maintenance of the building involved half of the estate, the houses on half of the estate, being repainted, redecorated internally, insulated, and given a general spruce, and the others not at all. Nothing was done on the others. I know it's unrealistic, but let's just take it as a hypothesis. Are you saying that it's still impossible when deciding what's proportionate or a fair proportion, for that fact to be reflected in the division?
Yes, and the reason for that is because that expenditure goes into the numerator. That's how this operates. It says that the annual service charge is this one lump sum, fed into by various different
I understand
requirements.
it goes into
and the when it talks about a fair proportion or a proportionate part, that is of the whole. There's nothing within the words of this lease which allows you to apply fair proportion at two different levels. To say we'll have a fair proportion of the whole. Oh, and by the way, we're also going to have a fair proportion of or disproportionate.
What I'd be saying is, I think it's fair that you take a slightly bigger proportion of the whole to reflect the fact that you lived in a house which was given all these service benefits, and somebody whose house was given no such service benefits should get a smaller proportion of the whole in terms of the charge.
Well, my lord, we've already
why is that outside the contractual framework?
It's outside the contractual framework because that would require you to, armed with your proportionality sword, to break into the annual service charge and apply your proportionality there, and then and so you're applying it twice. You're not applying it to the whole. You're applying it to the particular, and that is not what it says in the leases. That's what Judge Cook pointed out. Wasn't in the leases. It'd be perfectly possible to have phrased it so that proportionate part of the annual service charge, and then make some comment about how the proportions between the various different elements of that charge could be done, and it wasn't done. Somebody reading this will see that that you have the whole, and then you divide it. Now, if you're asking me what's wrong with that, isn't that obviously unfair? But that comes back to the point. In fact, my learned friend made, and is made in the first tier tribunal day in, day out, and fails day in and day out, and that is, oh, why should I contribute to the lift? I live on the ground floor. All the lift expenses benefit people higher up, and the further up the building you get, the more they benefit. And should I be paying for the roof? Because actually, the water never really gets down to my level, and people at the top might say, well, foundations are a long way away.
Yeah.
But
all those, I understand that all those sort of arguments are regularly thrashed out, day in, day out, in the first tier tribunal.
Yes.
But your contention is that there simply can be no departure for whatever reason, good, bad, or indifferent, from equality.
My argument, the point of the argument that we're having at the moment is about what the annual service charge comprises.
No, it's not. It's about how you divide up the annual service charge once you have ascertained what it comprises. Once we've done that entire exercise, everything that fits within 5.2, you've done that whole exercise. You've got the number. Now the question is, do you have to divide it up equally, or in the division, which has to be fairly proportionate or proportionate, can you reflect the fact that some of the whole, some part of the whole, was spent on services for the benefit of some but not others? Conceptually, I mean, it may be a good reason or a bad reason, and these things may not succeed, but why you say that is just not an exercise that this lease permits?
No, because that's, it isn't the way the lease is structured. The lease is structured at 5.1 with denominator and 5.2 with numerator. And if you were applying differential sums in 5.2, then it would say so. It does mention reasonably in one case, but it doesn't. But these concepts of proportionality are not introduced there. They could have been, and they weren't. And that was what the parties were contracting for. And the analogy for, say, half the estate being renovated, the other half not being renovated, that's not an unusual circumstance, because the renovation of estates can take several years, and it will appear in the service charge over those several years. And the fact that in a communal arrangement of the lands outside the building, which is what the FTT found, so we can be confident about that. That was the intention, all this open land, all these buildings opening onto it. Again, bespeaks equality in terms of the division. What the tribunal... to bring it back, what distinguishes the lease which isn't appealed from the lease which is appealed is that the lease which isn't appealed says 137. The lease that that are appealed talks about proportionate part or a fair proportion, which is not as rigid as saying 137. But the logic of that is the one that's arranged, that we see from the long-standing agreement, which is that the division became 138 when the caretaker's house became available. House or flat, I don't know which it is, became available, and so the denominator was changed.
How can you interpret a lease by reference to subsequent acts?
Well, what I'm saying is,
fundamentally contrary to the principles of interpretation.
No, not necessarily in landfall, I'm giving you an example of how those words might operate slightly differently without departing from the essential point that I'm making, and that is that a proportionate part is essentially a fraction. And that and that feeds into this kind of broader context, I would say, of having a unitary estate, an estate which has a good deal of features in common, which we get from the FTT, which is again consistent with what's being said in the leases, that these leases are not expected to be materially different between them.
Yes.
And that when it comes to it, it could have been said, as Judge Cook says. Let me just see if I can find her exact quotation. Yes, so it's page 76, paragraph 20. Clause 5.2 would have had to read something like a fair proportion of each of the following. It doesn't do anything of the sort. In fact, each of clause 5.2 requires the annual service charge to be calculated as a single proportion or fraction or percentage or any other synonym of a global sum. And to borrow your chastising of me over referring to something which happened after the coming into effect of the lease, there is a danger in terms of trying to construe something, a lease of this sort, of course imposing what we think should be fairness, rather than what objectively people at the time of executing this lease thought they were signing up to. In my submission.
What I'm trying to get at, and I'm sorry if I was attempting to chastise you, what I was trying to get at was the people who execute these leases sort of envisage that there will be a mechanism in place to determine what they pay every year, what proportion they pay of the annual service charge. And the difference between the parties is you say it has to be an equal proportion of the whole and cannot be anything different.
Yes. Although that proportion of the whole might change, which is under the leases, which is which are subject to the appeal. So it might not be 137.
Depending on the number of leases within the buildings as defined.
Yes.
Yeah, I get that. In other words,
if they break up one of the houses into two flats.
Yeah, I get that. Whereas Mr. Bates says no, we have the flexibility to determine for reasons connected with tenure that one of the elements going to make up the annual service charge shall be borne differentially by tenants.
Yes.
You say, well, he can't do it, as it were, stream by stream, because they're only just examples or complementing the real point, which is the whole. But the point I'm trying to put to you is, why, when you're dividing up the whole, can't you reflect, if it's rational and appropriate to do so, having regard to what these services are supposed to be provided for, to make some differentiation? And really that's the difference.
Yes, and I think the answer to that is that if there was a differentiation to be imposed on the numerator, then that would have appeared in 5.2, and it didn't. 5.2 is very clear over what the annual service charge is, and then the apportionment of that is dealt with in 5.1, and there is nothing to suggest in my submission in 5.1 that you can then, if you like, revisit 5.2 and start adjusting the sums accordingly. And the second aspect of that, which is which I say is iniquitous, is to try to impose what we would say, and my learned friend has been scrupulous about, only in extremis having referred to the evidence afterwards where some post hoc justification is tried to be provided for the £300. He's quite right. That's obviously going to be subject to a good deal of challenge in the first tier tribunal. But in terms of what the first tier tribunal was dealing with on this occasion, all that we had was a £300, I say we, I wasn't actually there of course, but was a £300 demand for each of those years in relation to management fees. Now, that proportionality or the proportion comment, obviously I'm pushing you towards treating that as a strict fraction, but on no analysis in my submission can an arbitrary sum like £300 be considered to be proportionate within that, and yet that is essentially, well, that is exactly what is being sought to be done in relation to this. It doesn't change from year to year, which I think is instructive, particularly given my Lordship's comments. It wasn't even introduced until 2017-18, and we get that from Mr. Darren Whitehead's statement within the bundle. It isn't something which, by any means, is given any universal approach in relation to this estate. We've got one property at least, which will be judged against 137th. We've got the vast majority of the tenants paying a 15%, as I think Judge Cook will describe it as a proxy for the management charge in relation to it. But nevertheless, the upshot of that is that 60% of the management fees which are coming in relation to this estate are paid for by 22% of the tenants. The long leaseholders are paying the vast majority of that, and often that management charge, as I've already pointed out, exceeds, again in evidence from my client before the FTT, exceeds the actual services, the cost of the services which were provided.
Sorry, where did that number? Is that number?
So those are in the witness statement of Sarah Jane Burns at page, the supplemental bundle pages 134, paragraph 50, and 143, paragraph 84.
Sorry, just give me a sec.
So 2017-18, management fee was 129% of the revised service charge element.
Just have to bear with me a second. I'm behind you. It's page 134. Which paragraph?
50.
Right, and then what was the other paragraph?
And then the other paragraph, that paragraph was 2017-18. 2018-19 is page 143, paragraph 84.
Yes, but so I thought the numbers I picked up or I heard them was that you're saying that the long leaseholders, which represent 22% of the
Yes.
whole.
Yes.
Where does that number come from?
Yes, I have got that from here as well. Hang on, that is page 133, paragraph 46. Right, so those two figures I was giving was a comparison between the actual service cost and the service,
Right.
and then the management charge. The figures for 22% of the estate. That's
Right, well, that's there.
long
It's the
leasehold.
last sentence of 46, in fact, is what you were quoting.
Yes.
Right.
And the significance of the management costs is that goes directly to Accent, whereas everything else is defraying monies which Accent should have expended. And that's, again, that is in the bundle, but it's, going directly goes directly to Accent. It's a comment made by Accent themselves in their description, but that's from the later material to go before the FTT. So what we have is frankly a highly disproportionate system. In fact, it's virtually the antithesis of being proportionate. If you're just going to impose a single charge year in, year out, which is supposed to represent management costs but has no apparent, at least we will contend, has no apparent relationship with the actual expenditure itself, and certainly nothing before the tribunal in relation to this matter before. We have a complete hodgepodge, really. So tier 3, shared owners, flats and masonettes, leasehold flats and masonettes, domus, bungalows, flats and houses, bungalows for the elderly, so on and so forth. You get different charges for freeholds with charges on the estate, or shared ownership houses and bungalows. You get 15% on charged on some tenants who will receive all of the services except for consultation in relation to essentially capital expenditure, big schemes in relation to the works.
Where do you stand on tiers?
The system of tiers is frankly quite arbitrary. When I
mean, I don't mean to interrupt your answer, but is it in fact a corollary of what you're saying is that against a lease of the kind that you have,
yes,
the tier system couldn't survive?
Yes, that's right. Yes,
yes,
the tier system doesn't survive
that's the
under
corollary
the
of your
construed. Yes.
of your thesis. Yeah.
Yes, that's right. But
and that's because you say two reasons. One is you say, first of all, it's not equal. It doesn't involve an equal distribution of the annual service charge as defined. And secondly, you say because the justification offered for the tiers has nothing to do with the provision of services by the landlord to the tenant under this lease.
That's right. That's right. There's always complete disconnect. And in fact, as I say, it's slightly worse than that because
the first of those arguments we have to decide.
Yes.
The second argument is one that if you lose on the first, you can run in front of the FTT by saying that the justification that's been offered is irrational.
It's not reasonably incurred.
Given it's arrived at for an irrelevant factor, and therefore it cannot be either a fair proportion or a proportionate part within the meaning of 5.1.
Yes. Also, though, I would offer this, and that is that the actual impact of sweeping away the tier system is not at all clear from any of the material. My only friend talks about more than 1,000 units. We've had no figures in relation to that. That's less than 5% of the stock of the appellant. Also assumes that that most of of those 1,000 or however many there are, some of them might have specified 137. We know that in relation to one, there might be a large number of those. So, this general attitude is going to have a swinging or deleterious effect on the appellant is, in my submission, incorrect. We've seen one of the cases which is in the authorities bundle. No, hang on, I apologise, it's not in the authorities bundle, I think it's in the second one, deals with the Hemlington estate, which is only a few miles away from the current estate. Yes, this is in the supplemental bundle at 116. This is an estate which is very would appear from its description, which is under the property. So the property concerns a two-storey building, front door access to which directly abuts an adopted public footpath. Opposite side of the building, which is property, two-storey house occupied by the respondent scheme manager. Opposite side communal.
We're on 117, are we?
The simple point that I was just going to make in relation to that is that that was consideration of a similar scheme, similar arrangement where the service charges had been imposed on a differential basis, and the tribunal.
Can I just ask? I mean, I'm not sure I necessarily get much from this, but
No.
at page 117, the relevant provision seems to have had something obliterated from it, because it says the lessee shall pay to the lessor annually a blank part of the annual service charge as hereinafter defined. Has somebody sort of used a highlighter on that or something to delete the critical word? What is it?
No, as I read it, it appeared to have been left blank by whoever made it. It appears to be yet another problem with the leases. As I read that case, if you jump to page 121...
So the problem is there was actually no guidance as to what part was to be.
So as I read what the FTT did there on page 121G, management charge, they basically threw their hands up in horror and said, well, we've got to work out something in there. We're going to stick in 15%. Because it had all been left blank. Clearly something was supposed to be charged, but had
Something went wrong.
Yes.
Okay.
Yes. I think Mr. Don, your argument has a great clarity to it, and I'm wondering how much more it gains by other materials.
If you might just give me a moment.
Yes.
Yes. Apologies, there are certain notes to be dealt with.
Yes, of course.
I think what it comes down to is that the proportion or the fair proportion is, essentially reflects the fraction that we see in 137. We've got a numerator which is very clearly stated. It could have been stated differently if my learned friend had been right. It wasn't. It's very clearly stated how that operates. And then we get an apportionment of it. And if what we say essentially when you start, that is that the start point in dealing with that apportionment is equality, and that is fundamentally as far as you need to go. That is the arrangement which is in place. What you cannot do is apply that proportionality more than once. The numerator and the denominator are separated out. And when you start from equality, then that is frankly enough, in my submission, to reject the appeal. There's nothing wrong with the approach taken by Judge Cook in relation to it, because she has faithfully followed what I say is the clear words, and what I say is the clear intention. There is no intention to depart one from another in relation to the treatment of the estate. The way that the whole lease is framed does not bespeak differentiating one type of property from another type of property. That could have been done, and it wasn't. There is no reason, on the basis of my learned friend submissions, to depart from the way that has been expressed. Unless I can help you.
Thank you very much, Mr. Devine. Yes. Is there any reply?
Very briefly, 6 points of which, after the first two, they're exceptionally short. It's critically important to start with my submission to keep conceptually separate in our mind two different bits we've been talking about today. The in-principle question that arises in the appeal, yes, and whether, if I just to phrase it again, just to clear here, we say that an unequal allocation of parts of the annual service charge can still lead to a charge to a leaseholder that is a proportionate part of that annual charge. And that's the in-principle question. Are we right? Can you have unequal parts of the annual service charge still leading to a proportionate total charge? If we're wrong about that, nothing else matters. If we're right, that's when we get, as my lord was saying, and when my learned friend was actually facing on
Yes,
fire.
so you may have won the battle, but you may still lose the war.
Exactly. That's the question on the appeal, the in-principle one. It's entirely possible that we could win that appeal, but get back in front of the tribunal and have them take the tier system apart, have them tear apart witnesses, etc. And that's the remitted question.
Yes, and also it's theoretically possible that on a rehearing it'll end up that the service charge was an undercharge.
Entirely possible, yes. But for the moment, it's only that point of principle. One of you, my lords, asked if there's a definition of service charge. There is, I'm not sure.
Just before you leave the point of principle, I don't actually think that's the question, or certainly not the only question. The question is whether you can divide up the annual service charge as defined other than in an equal proportion.
Yes, I think that's another way of putting the same point.
Well, no, I mean, because that doesn't require you to talk about parts of the service charge. See, Mr. Verdon's point is there is one annual service charge as defined, which is the whole, and the question is how do you divide it up between leases?
Yes.
And the question is whether you can divide it up other than equally.
Yes.
He says no, you say yes. Yeah. How you justify dividing it up other than equally, you don't get to on his argument if he's right.
Yes, I agree.
If you're right, you still have to justify.
Agreed, yes. Yes, agreed.
Yep.
I think we're there. One of, I forget, sorry, I think I noted a few, but someone asked if there's a definition of service charge. There is, although I'm not sure it will help. In the authorities bundle, if we look at the Waller case at page 163, which is behind tab 9, a decision of this court paragraph 15, Lord Justice Lewison sets out section 18(1) of the Landlord and Tenant Act 1985. This is where you find the statutory definition of service charge. An amount payable by a tenant of a dwelling as part of or in addition to the rent, payable directly or indirectly for services, repairs, maintenance, improvements, insurance, or the cost of management. So those are the permissible items. And then for it to be a charge to which all of the regulatory provisions apply, because this is the definition that brings you into the protective legislation, it has to be one that varies according to the relevant costs. The relevant costs mean the landlord's underlying costs. So it's essentially a charge that goes up or down depending upon what's actually spent at the building on the services, repairs, maintenance, improvement, insurance or management. That's the statutory definition of service charge. And you contrast it with fixed service charges where you could spend it on repairs, improvement, etc. But it's set out in the lease at £500 going up by RPI, let's say. In those circumstances, you don't get all the statutory protections because you could foresee with a degree of certainty what the charges would be likely to be. I don't think this helps, but someone else.
Well, it sort of does, in the sense that the definition in the leases is consistent with it.
Yes, which is hardly surprising because the Millennium says they're right to buy leases. Yep. So they're lifted from what was at the time the Housing Finance Act 72, where this used to be before the 85 Act. So the regulation of service charges goes back to the early 1970s. The definitions have barely changed. Hence the concepts in the leases haven't followed through. The reason why in my skeleton I suggested there were 6 streams is you've got, streams have been helpful language, but to be fair to myself, you've got A to E in the lease and of course the reserve fund. That would be the 6th stream there. And then final point, just to come back on, my learned friend was suggesting to you that the right to buy itself may give you some of the reason why equality is an answer here. That's a bad point, if I may. the right to buy legislation from its earliest days in the Housing Act 1980, now in the 85 Act, has had certain terms that must always go into leases, but it's never dealt with how you apportion service charges, for the obvious reason that you couldn't possibly foresee that at parliamentary level across the entire range of social housing stock. So that's not an answer to that. That's all I wanted to come back on. Could I just check in terms of homework for my learner friend and I? Does the court still want a short note on the different regulatory regimes that apply in private and social sectors? And a note on the statutory control of service charges?
In the broadest practical terms, please. It's contextual.
I'm aiming for a page on each to set the frame.
That'd be very helpful.
And thirdly, in terms of homework, without getting ahead of myself, should my learned friend and I also prepare for you possible remitted questions for the court to consider?
We're going to ask you, obviously, to prepare a draft order that reflects our decision. If our decision is that way, we think that it would be sensible to have in broad terms the issues that are being raised.
I will park that then until the circulation of drafts in the usual way, if that's all right. But I'll do the note. I think my learned friend and I hope we can get it to you by Friday, but certainly Monday.
Well, it's a kindness of you to do it, so as soon as you reasonably can.
Thank you very much.
Now, thank you very much, Mr. Bates. Just for completeness, it doesn't look as if you do, Mr. Vadine, but anything you wanted to say about the Wala case? I wondered whether we were going to get to the end of the day without, in fact, referring at all to the authorities bundle.
I've nothing to add on that. My learned friend is correct. I was perhaps thinking of too much of a general level rather than the particular in terms of the statutory control, which is, of course, what that definition deals with.
Well, thank you. Very well. Well, we'll think about this and let you have our decision as soon as we can. You'll know that the judgments will be handed down in draft to those who are on the list of those who are to receive them. We'll be very grateful for any corrections of an editorial nature and for a draft order reflecting the decision as we've just discussed. If there are any matters that you can't agree about, then of course give us some brief written submissions and we won't trouble you to come back to argue them. We'll deal with that on paper. And in due course, the judgments will be published on the day fixed for hand down. But thank you for your help.